Speaker is Mike Burnt, our Chief Legal Counsel, who's going to give us a primer on open meetings and maybe a little parliamentary procedure stuff too. Would you like the mic, or do you just want to show up?
Looks like a long way back there. Can people hear in the back?
Yeah.
Sometimes. Depends on the speed.
Okay, well maybe I'll try without the mic. Does this sound pretty good? All right. Okay, well, good morning, everybody. And before we get started, I just want to thank everybody for attending and taking time out of your days and your busy schedules to be here. I really think the more you know, the better a board member you will ultimately be. The other one thing I want to say is that what you're going to be hearing today are a lot of legal concepts. And I don't think many of you are also attorneys. You are experts in your professions, but you're not attorneys. And so certainly I always encourage you, if you have questions, talk to your executive director, talk to your legal counsels, talk to whatever staff people you need so that you make sure you get those questions answered. We want to make sure that you have the ability to be acting correctly. Another thing I always point out to people is that ethics, and I heard, I know you had some ethics earlier. There'll be ethical issues in terms of the open meetings law because it's an ethical violation to violate the open meetings law. Ethics are not always intuitive. I may think you are all ethical people. You may all truly believe you are ethical people. Yet the way the law is written, it doesn't presume you're ethical. It presumes there are people out there trying to get around ethical issues, trying to evade the intent of the law. And so, always keep that in mind. Ethics simply are not intuitive. We all think they are, and when I first heard that, I thought that was kind of a strange statement. But when you think about it, that's really true. And then when you look at how the law is written, it doesn't assume you're ethical. It assumes that people are out there trying to potentially commit violations. So, whenever you have ethical questions, if you have an issue, again, talk to your executive director, talk to your legal counsel. All right. The first thing I'll be talking about is open meetings. Okay. Turn on. And this is language from one of the statutes. I'll give everybody a chance to read that. And not only is that wording in the statutes, but this is a paraphrase of a subsequent section of the statutes. Open meetings laws to be broadly interpreted to promote the policy of openness. And I've seen over the years, whether it's open meetings or public records, courts truly do take that to heart. If you have a close question or something that's unclear, a court will likely prefer an interpretation of the law that favors open government. And the same things apply, the same type of concept applies to open records. Courts disfavor interpretations that would facilitate the evasion of the policy of openness. Now, open meetings law applies to meetings of governmental bodies. Governmental bodies as a definition, but for purposes of today, we won't go into all the other definitions. All the boards, all the councils, all the affiliated credentialing boards, all the sections are government bodies. There are two important concepts you have to convene. It also has to be for a purpose that relates to your duties. And that's set out in one of the key cases, the Showers case. It talks about the purpose requirement and the numbers requirement. Now, first we'll talk about purpose. I just skipped over those slides because I know we're in kind of a tight time frame here, but the purpose is broad. It's preliminary decisions, it's discussion, it's information gathering, and you don't even have to be together interacting to be engaging in one of your purposes. So definition of purpose is very broad. Now, how many members does it take to constitute a meeting? Well, it's a sufficient number to determine a course of action by the body. And a warning down at the bottom, that may not even be a quorum. Clearly, if you've got a quorum present, you have enough to determine a course of action. So, that sufficient number would be the affirmative number to pass a motion, or the negative power to defeat a motion. And that later concept, the negative power, is called a negative quorum. Okay, you must also convene for there to be a meeting. But that's not limited to face-to-face gatherings. It includes any situation where you can communicate. So, some obvious situations would be telephone conference calls, video conference calls. You can communicate verbally in an instantaneous way. And as a practical matter, that's like being together in a room. More recently, there are other forms that you have to worry about. Email, electronic discussion boards, instant messaging, or social networking. Arguably, you could have a meeting on Facebook. So that's something to be certainly aware of. And maybe I should have used stronger wording here, that electronic messaging may or may not implicate the Open Meetings Law. Caution is advised. It definitely does, I think, implicate the Open Meetings Law, and you can't do that. If there are communications with the quorum of the board like that, it is a meeting. And again, if you're not physically together, the key question is, does this resemble a face-to-face interchange? Now, another thing to think about is the concept of a serial or a walking quorum. And this can occur when you have a number of small meetings with different parts of your group. And it can even occur if you tell somebody to go tell somebody else something. And it could be you can't use intermediaries. That still would be a walking quorum. Here are the elements of a walking quorum. Series of gatherings, smaller than the quorum, where you agree to act uniformly, and ultimately it encompasses a sufficient number to control that body. It's intended to prevent the attempt to circumvent the law. And without going into war stories, I've had different board members wish they could have lots of communications and talk things out ahead of the meeting. But you can't do that. You can't all come to agreement before on certain items before the meeting. That's why you have public meetings, public notice of the items to be there, a chance for everybody, not just those in that special loop, to be able to speak. And when we talk about rules of order, that's kind of a key concept. Both the majority gets an opportunity to have input as well as the minority. Again, the practical tip, things like walking quorums are complicated and fact-specific. If you have questions, talk to the legal counsel or to the executive director. Meetings don't necessarily include social gatherings. However, you should be aware if more than half of you are present at some gathering, then there is a presumption, and this is again one of those situations where the law presumes that there's a problem. And there's a presumption that you were there for government business. Just going back to that slide, I just do have one more comment. There have been situations, for example, where a board meets or a city council meets, and then they all go out. In this case was old, they call it a lounge. They all went out to a lounge after the meeting. Well, what do you think they talked about? And a quorum was there. That was a meeting, but it wasn't publicly noticed. And so that would be a problem. And the same thing, we have situations where board members attend or we want to have a dinner, for example. What we sometimes will do in that situation is put out a notice saying a quorum of the board will be present at such and such. Board business will not be conducted. So if you ever wonder why we do that, that's because the law assumes that if you have more than a quorum present, you have a meeting. Okay, every meeting must be preceded by a public notice. That must be communicated to the public. And we, of course, put it on our website. It must inform the public of the time, place, date, and subject matter of the meeting. And it does require some level of detail. And there are some things that we'll go into in the next slide or two that help set that out. But you have to look at a few things. We can consider the burden of providing more detail, the degree of public interest, and whether the subject is non-routine. And as boards, you deal with some routine things, but also many items that are of great interest to the public. Some terms should not be used. Greg is sitting here, he knows these terms too. Old business, new business, agenda revisions, miscellaneous business. That doesn't tell the public what's going on. To the extent you can clearly tell the public what's going on, it should be identified. If a closed session is anticipated, that should of course be noticed, as well as what's going to happen in the closed session. Notice must be given in a timely way, and I can tell you that there's a very high burden to do a notice in less than 24 hours. I'm probably never going to approve that. You at least need that, and we normally put the notice out even the week before. I think the notice is generally put up on Wednesday for meetings the following week. You can't notice groups of meetings. They have to be noticed separately. And then there's some specific things. An open session, for example, I think some of the boards have run into this. That's not the slide I wanted, but if you have an open session, you can't go into close and go back into open unless you've noticed that. You can move to something later in the day. If you adjourn or recess to another date, you need a separate open session has to be in an accessible place. Should of course be in the state of Wisconsin. where you're supposed to have adequate room size and acoustics and have it physically accessible. Skip over these. Actually, we'll go back to that. If you have an open session, we should have an open door. It should be unlocked. If by chance you have to be moved to some other part of the building because of room conflicts, you'll have a sign on the door saying it's an open session. Then you're in compliance with the law. The public has a right to attend and to observe. There's nothing in the law that requires the public to be able to speak. That's not a requirement. However, you can put on your agendas public comment as an agenda item, and you can have a period for public comment. I think most of the boards do that out of respect for the people who are attending who may want to say something. During that time, you may receive information. You can discuss it, but then I normally warn boards, you should keep that discussion relatively short, and if it's really something you want to take up, you put it on your next agenda. But what you can't do is take some type of formal action. That really has not been noticed, and other people wouldn't have an opportunity to come and speak. Another thing that's come up a few times for boards that have things of a lot of interest, you have an obligation to let people photograph or record. There's no prohibition on people recording what happens at a board meeting. However, you do have the ability to make sure it doesn't disrupt the meeting. So we've had situations, I know of one board in particular, where we've allowed microphones to be placed at the head of the table so they could get recording, where cameras can be placed in the room, but it can't be such that it interferes with the ability of the board to do its business. Okay, voting. No secret ballots except for electing officers. Any member may require a roll call vote. Motions must be recorded and preserved. And voting records must be made available to the public. The open meetings law does not require that you actually keep more extensive minutes, but for various groups that might be required by other provisions. Now, as to closed session, meetings should begin in open session, but to go into closed session, you have to make a motion. And I think all of you are used to that, reading the long phrase of purposes, and that's required. And the vote of each member must be recorded. So that's just not a quirky thing we require boards to do. That's specifically required by the law. The thing you read to allow the move to closed session has to set out the statutory exemptions and the nature of the business to be conducted. We have a question.
That's fine. Can you explain why we have to disclose when we go into closed session? We are going to deliberate over an infraction of in our case, pharmacist, and it seems to be it's public, and then it's in the agenda, it's in the meeting. It seems a little, it's a little, I don't know, unnecessary sometimes. Sometimes, a lot of times there is a major infraction, but sometimes it's kind of borderline, and it seems like public flogging in a way that may be necessary. Do we have to list names on it? Is that a requirement on this slide? Making myself clear?
No, I think I understand, and I'd have to look at your specific agenda and the whole thing. But generally, the law favors more information and a good description to the extent possible what you're doing in that closed session.
And it mandates names.
And I think it'd be a problem if you just had a general description considering disciplinary matters. That probably is not going to be enough. Now, another important concept, if you're in closed session, you have to limit your discussion to the specific business for which the closed session was authorized, and not take up other matters. I know you, sometimes boards will go into closed session, all of a sudden they want to start rehashing things that happened in open, or think they're in closed and now can talk about anything because the recorder's off. And that can't happen. When you're in closed session, you're supposed to be staying to only those topics identified as the topics for closed session. That's why you went into closed session. So anyway, many boards don't do that, but I've seen situations where it's really tempting to want to go and rehash something that occurred in open, or to now talk about other things. We've also had questions about who can attend closed session. And that is largely in the discretion of the board. It's who you think is necessary. So that's why staff will attend. Sometimes we've had people come in for training who will be working with that board in the future attend. The board has the ability to make decisions about who will attend that closed session. The specific reasons for going into closed session are identified in the statutes. And all the things that we do in closed session, such as considering disciplines, some licensing issues, certain denials, that's all authorized. Consulting with legal counsel, those are all specifically authorized. And when that list of statutes are read, those are all included in that list. There's a little difference in some of the case law in voting in closed session. There's a case that says if it's integral to handling the matter, you can vote in closed. Then there's a more recent case that says you should vote in open. And I think all of you know that most boards do certain things in closed and then come into open session and do a vote. And as you'll see in the last bullet point there, that is what the Department of Justice, who is one of the bodies that can enforce the open meetings law. As we'll talk about later in enforcement, DAs can enforce it as well as the Department of Justice. They recommend a vote in open session. Again, you can return to open session after closed session, but that should be noticed. If you've done all your work, you can adjourn right from the closed session. Okay, enforcement.
Mark,
Yes.
just one question on the last slide. If you notice it to go into and then back to open, can you decide not to go back into open? If it's noticed the other way.
I would go back into open if you've noticed it that way.
Okay. Yeah. Thank you.
Yeah. There's just nothing in the law that requires there to be another. You could have your. But if you're going to have to go back into open to vote on anything, you're going to probably be going back into open anyway.
Thank you.
Okay, enforcement alternatives. Violations of the open meetings law can be enforced by the local DA, by the Attorney General, or by a private citizen. If it's a DA, it would be in the county where the alleged violation occurs. So here it would be the Dane County District Attorney. They must receive a verified complaint, written, signed, and sworn, and that's in the law. Now, the Attorney General can also enforce violations, but they tend to only want to become involved if it's statewide matters. They normally prefer that somebody go to the local DA. However, if a DA fails to act within 20 days, the person who made that complaint can bring an action, enforce the open meetings law. And I'll just note, if they're successful, they can also get their attorney's fees. The penalties for open meetings violations set out there, $25 to $300 per violation for any member if you knowingly violate the law, attends a meeting or otherwise violates the law. I wouldn't want to be going here, but if you act in good faith on the advice of legal counsel, you probably won't get in trouble. But that's not, we don't want to be cutting it too close to the line. Usually with ethical things, I never suggest get close to the line. You want to stay away from that line. But if you're acting in good faith, relying on legal counsel, you probably wouldn't be found lying. There's also another enforcement remedy. If an action is taken at a meeting in violation of the open meetings law, that action may be void. And I did see a case where, in fact, that was a situation. In that unfortunate case, that body had apparently been meeting illegally for 3 years. So they kind of had a track record of violations, but the action they took was voidable. Courts don't like to go back if bodies are acting in good faith and void things, and that probably won't happen. But where you have blatant situations, you could have board actions be voided. Two things here. One is questions. The other thing is, it says portions copied from the DOJ open meetings outline, which is on their website. They have a much more extensive outline on their website, and portions of these slides are from that. They gave me authority to use them and I guess to modify them, but not represent it's a DOJ presentation. So, in any event, any questions? Yeah.
Is it a violation of open meetings law for board members to email other board members to solicit them to vote for them when there's elections coming up? They just send it, one-to-one versus, that just didn't seem like it was quite right to me. That was
Yeah, and that's something I'm going to have to check on, because I know that unless one of the legal counsels has any advice on that, I know that issue came up, and I did look at that a few years ago as to whether that's board business and whether that's been carved out as something that does not fall into those other restrictions. I don't know, Greg, do you remember anything about that? So I can't say yes, but right now that's okay. But it's something I would have to get back to you on, because I think there's something carved out for that type of communication in some AG's opinion somewhere. But I did not read it in preparation for this meeting. Okay, and Greg will make a note of the question so we can get back to you on that. Yes?
And I'm not trying to play stump priest here, but if you have, as an example, you have 5 members of the board, 3 of which it would be a quorum. So technically, because they can convene the 3 of them, therefore 2 of the people on that board talking about something could be a violation, because you could have a meeting with 3, 2 would be a quorum of 3. I mean, I've seen this discussion before, and I'm just wondering,
Well, you know,
how far
With-
can you carry this?
with the small boards, it becomes particularly problematic.
Right.
You know, where arguably 2 people could be certainly a negative quorum for certain types of actions.
Right.
You know, if you're talking about, if the 2 people got together and talked about, on a 5-member board, about an issue related to suspending or revoking a license, that'd be a problem. But with the small boards, we run into that even with the issue of board chairs voting. You know, there are just all kinds of problems when you have the very, very small boards or sections, because these laws apply regardless of size. Any other questions? Yes.
We get our agenda and appropriate information on a Friday, and our meeting's on Wednesday. And it seems like there might be 10 or 15 items added to the agenda. Can they legally keep adding up to that 2-hour time posting before the meeting? Or is there a time where we can cut off additions to the agenda, legally say?
Right. And that's something, you know, to work out with your specific executive director, but there has to be 24-hour notice. So I don't know, Greg, if you're aware of any situations where we haven't had at least a 24-hour notice. Since you've been, I can't remember anywhere we've approved 2-hour notice. So there'd be a time frame where what's on the web would be updated. And normally it's going to be 24 hours. In less than 24, we're not going to approve. Yes.
If a board was going to conduct business via conference call as an official meeting, how does the logistics of making that open to the public work? Is it that any public member can call in and listen, or how do they facilitate that?
Yeah, and I think and maybe Greg can answer this better than I can, but I know one thing we've done is you have a room available where there's a speakerphone, and there would be a place the public would come and sit, and where staff set up like it's a meeting and they do the work, and somebody could come right in and I believe that's what they're doing now.
Yeah. So in your case, I mean, literally, we'll have, in some of our, this happens quite frequently, so you'll have Tom, or in your case, Dan Williams, you know, literally sitting here at the table with the Polycom unit in the middle, with, everybody in the go-to meeting, teleconferenced in. You can hear everything in here, and so that's the individual's venue to come and listen. Everything happens. It's set up just like a regular board meeting.
Okay, any more questions? All right. Okay, the next presentation is on parliamentary procedure. And we saved this really interesting presentation for the time right before lunch, because we knew that if it ran over, nobody would be concerned. We'll just work right into the lunch hour on this one. But I wasn't worried about the time, because I do not plan to go through this whole outline. It's too specific and detailed in some regards to go through this whole thing. These will be on SharePoint. The other important thing to note is I am not recommending boards adopt Robert's Rules of Order. I collected 4 or 5 copies of them over the past couple of weeks. Every version's a little different. There's a lot in there that's contrary to the statutes. In terms of quorums and what you need to do certain actions. And so I'm not suggesting boards adopt that, but in looking at it, well, another thing I'd say, I've been to many board meetings. I think a lot of the important principles actually are met by how you function. And we'll go through some of these basics in some of these slides. So to a certain extent, I'm not sure we have a problem that needs to be fixed. And I'm not sure that adopting Robert's rules would be a way to fix it. So, with that said, let me start this presentation. Well, we might not need Robert's rules. I think you do need some kind of rules or conventions by which you conduct your meetings. And ideally, however you do it, should provide for fair and orderly meetings. They should promote the majority's right to decide. The minority on any issue should have the right to be heard. And absent members should also be protected in terms of notice of what's going to be happening at the meeting. Robert's rules were written by General Henry Robert in 1876. It's kind of interesting. He presided over a meeting at his church, and apparently the meeting got out of hand. And so he was greatly embarrassed, it says. And so he saw the need. It compelled him to write this lengthy book with fine print. So it must have been pretty embarrassing. But it's also important to note that over the years, and with all types of other different bodies, like the British Parliament, for example, there have been rules of procedure that existed long before this. And just some general comments. Usually, out in the real world, entities have the power to decide how formal they wish to be. We, of course, have some statutory requirements that we can't ignore. Bylaws, rules, things like that are set by the body. And I reiterate here, well, one other comment about that. Oftentimes, smaller groups can be less formal. The larger the group gets, there's probably the greater need for more formal rules and ways to proceed. And again, I note, I'm not recommending a board go and adopt Robert's rules. If they are adopted, it takes a few meetings to change that. And then there's an interesting quote that we'll come back to. People who enjoy meetings should not be in charge of anything. And I read that and I wasn't sure what that meant. I was concerned because sometimes I enjoy meetings. So it was kind of disturbing. But but I decided there's a way to read it that's better. We'll revisit that. Okay, the basics. And I think most boards actually try to emulate this. We have the rules to make the meetings flow smoothly, to help people work together. That's what we're trying to achieve. And that's what we hope at the end of the day you've done. We also want all members to be equal and to have equal rights. Therefore, every member can make a motion, and of course, motions should be clear and precise. And then the big one, motions should be fully discussed with each member having an opportunity to speak. And to a certain extent, I always view that as falling on the board chair. When you conduct a good meeting, it's not just the people who want to get out there and talk. Bring out some of the board members who don't speak, who are sitting there maybe not in agreement. Maybe ask them what their thoughts are on it. So it's important to have a good meeting, to have everybody talk, those for motions, those against them. And that's a principle I hope we always abide by. Only one person should speak at a time. And only one matter may be dealt with at a time. I've seen one or two situations where suddenly you have a couple of motions on the floor and amendments flying around. You don't know what you're dealing with. You deal with one motion, one amendment to that motion at a time. And there's a certain order to which motion should be taken up. Finally, the majority vote rules. Those are kind of the basics. And I have to find my sheet of paper here. So, going back to that quote, again, I'm not sure about it, but I prefer to think of it, people who run open, fair meetings should be in charge. So, and that's what we should be trying to achieve, good, open, fair meetings where all the members have an opportunity to participate and share their ideas. Now, because I knew we'd run out of time, I can tell you that on the website you'll find a sample process that are entitled DSPS Rules of Order. And we're not going to go through these, but it covers kind of how it normally proceeds, including quotes of what happens. We've got a discussion of motions. There's quite a bit there, so take a chance to read through that. How you make amendments, the ability to reschedule or postpone, how you can refer things to committees, how you change a prior motion, information about voting, and then adjournment. That's a lot of detailed information. It's kind of a brief outline of how we tend to go through the process. It would be especially helpful for board chairs to probably go online and to read that. It's kind of a simplified version. And I would also thank Pam Stock sitting in the back, who gave me a lot of good information for this, and an outline which she probably recognizes was transformed into a PowerPoint with some minor changes. So anyway, any questions on rules of procedure? Okay, well, I encourage everybody, especially the chairs, to take a look at that sample process. It kind of, or for new board members, it kind of walks you through how we go about it, and it also accounts for some of the situations where statutes control what you do, because if you're sitting in a situation not where you're completely controlling how your meetings occur, many of the things are governed by statute.
That's accessible on the DSPS's main webpage. Is there a link?
It's going to be on SharePoint.
We'll have it up on SharePoint.
I think all the presentations, as I understand it, will be available on SharePoint. And like I say, if anybody's interested in open meetings or public records, there's good information on the Department of Justice website, a more extensive discussion of those issues. All right. Well, thank you very much.
Hey, nice job. Like Mike said, all the resources will be up on SharePoint that you're seeing today, including videos. Once they're edited, it might take a little bit, so bear with us. We'll make, if your board isn't on SharePoint, talk to your executive director, and we'll get the resources to you somehow into your hands. So it's time to break for lunch. A couple of notes as we do that. If you could, just go through the opening on the way to C to get your lunch, and then come back around and circulate back into the room here, just to kind of keep things nice and orderly, right?
Very important.
Very important. We'll have bureau assistants walking around, Dan and Matt, and Milena will be walking around with reimbursement forms, just making sure all your paperwork is square for today. And then just one thing too, if we only ordered enough lunches for everybody who RSVP'd, so if you came today without an RSVP, there might not be a lunch for you, but see me, and we can point you to some resources and things like that could get you fed. Mike's probably on his way to Subway shortly anyway, so. Thanks, and we'll see you back at 12:30.